about collections and garnishments. First of all, how's everybody doing? Are you all right? We need to stand up, a little stretching. Can you hang with me for 20 minutes? 20 minutes? I can't stop you from walking out if you can. 20 minutes is what I've got. What do you think about the stand-up? I say stand up. I want some blood flowing here. Stand up, a little stretch. I was teaching a seminar one time to some contractors. They've been there all day, and I was one of the last guys. And I told them all to stand up, and about 3 of them just walked out and left. There's a risk to that. So, all right, sit down when you feel comfortable. I appreciate that. Just want to keep you awake here. Just everybody pick up one of my handouts. It says Utah Courts at the top, and it's about some of the collection things I'm going to talk about. Anybody who doesn't have one, I've got the rest of them right here. So if anyone's looking, I've got those here. Anybody need those? All right, let's talk about collections. First of all, the things you can do to improve your chances of collecting before you've even got a judgment. Have a good application form that has the tenant's social security number and their birth date on it. For us to get a default judgment, meaning we sue them and the tenant doesn't come up and answer, we have to submit a declaration that they're not active service in the military for everyone. They could be 70, doesn't matter. You have to submit that. To do that, we have to go to a Department of Defense website. Ironically, whenever I go to that website, it has a thing that pops up that says their security certificate has expired, which always I think is interesting for the Department of Defense. But we have to enter their social security number and their birth date to get a certificate that says they're not active duty. Very helpful if we have that ahead of time. We don't have to track that down. It's great to know their employment. Garnishment is a great way to collect, and we'll talk more about that in a minute. It's nice to know about their bank accounts. You can try a garnishment at the bank to see if there's any money there once you have a judgment. It's nice to know their nearest relatives or other ways to try to find them. Like Jeremy said, it's difficult sometimes because once they move out, your last known address is your property. You don't know where they are, usually, and it's a little hard to track them down. Anything you can get from the application that helps with that is nice. It's nice if you have someone you're worried about their ability to pay to have a personal guarantor. Maybe it's a kid not that old, maybe 19 or something moving out. You're a little worried. See if you can get parents maybe to co-sign or to be a personal guarantor. If the kid doesn't pay, you can go after the parents. They're liable for the same thing. That's helpful on collection as well. And finally, just don't wait too long. The easiest dollar to collect is the one that never got racked up. Okay, so if you get them out quicker, then you don't have as big a bill and it's not so hard to collect. All right, collection prior to entry of judgment. This is kind of rare, but say someone moves out, they know there's a balance owing, they actually communicate with you, so you're still talking to them, they want to work it out. You have some leverage and you can talk to them about trying to get some money paid. The leverage you have is a negative report to potential future landlords. You can send it to a collection company that might have a negative credit report that goes along with that. You can initiate a lawsuit to collect. Those are things you can kind of threaten them with and hopefully they'll get something taken care of. Most of the time, you don't get that cooperation, and you end up getting a judgment against them. So I want to talk about a judgment. Here's a little quiz for you. What is a judgment? What is it?
The judge's opinion.
A judge's opinion, a judge's written document that does what?
Allows you to execute.
Allows you to execute. It basically says, this person owes you money. Okay? That is a judgment. There's different types of judgment and relief you can give in a judgment. Sometimes a judge can order people to do something specific. For example, a judge could order them to say, turn over to them the vacuum cleaner that belongs to the landlord. That is a judgment with a specific direction. But mostly we're dealing with monetary judgments. They're saying they need to pay you this much money. Small claims, sometimes you may choose to go to small claims court to try to collect. There is a jurisdictional limit of $10,000 in Utah. So anything up to $10,000, you can actually go do yourself in small claims court. If you are operating through an LLC, usually you cannot sue through an LLC and have yourself go in and act for that LLC. Small claims is an exception. They allow the principal of a company or an LLC or a corporation to go to small claims and actually do the case. Anything in district court, you're going to have an attorney for that business entity to appear and do things in court. Small claims judgments have all the collection remedies that district court judgments have. Because it's through the small claims court, the way you go about doing it might be a little bit different, but they're every bit as enforceable and you have all the same remedies with those. So what does a judgment do? It gives you the right to pursue certain legal procedures to obtain money and seize and sell assets in an attempt to collect your money. Now I want to talk about what a judgment does not do. And to do that, I want to compare it to a fishing license. All right, anybody have a fishing license in here? I do, I have one in my wallet. Fishing license gives you a right to go out and try fishing, right? Does it guarantee to you that the body of water you go to has fish in it? No. Does it guarantee, even if the body of water has fish in it, that you will catch any? No. It just gives you the right to try, all right? That's kind of what a judgment is. It gives you the right to try to get money from this person. It does not guarantee the debtor actually has money or any assets that you can use to collect. It does not guarantee you'll be able to find those assets. It does not guarantee that the assets you want to seize are not exempt under state law. There are some assets you just can't go and get because the legislature has decided there ought to be bare minimums that people can keep even when they have creditors coming after them. And it does not prevent them necessarily from filing a bankruptcy and potentially discharging or eliminating their obligation to you. So think about it. Jeremy talked about you want to have a good claim and you want to have the ability to collect. If you don't have the ability to collect, the best claim in the world doesn't necessarily mean that much. You have to weigh that. And I try to do that with my clients. I'm sure Jeremy does as well. Is this worth pursuing? If it's just a collection issue. And you have to kind of decide those things. All right, collection, who and when. A judgment may be collected by the judgment creditor, whoever's named in the lawsuit, and gets the benefit of the judgment. Most judgments can be assigned to someone else. Sometimes you may have an opportunity to sell a judgment to someone for pennies on the dollar. Maybe you have a $10,000 judgment. They said, I'll pay you $1,000 for that judgment. And you can say, all right, give it to them, and they stand in your shoes, and they can go try to collect just like you could. A judgment may be enforced against the judgment debtor, the defendant, usually the defendant in the action. You can't enforce an event against somebody else. If you happen to have a lease where the person who signed the lease, the tenant, was a company, and you get a judgment against that company, and you know the principal of that company is a guy named Bob, you cannot go take Bob's stuff. You can only, with the court procedure, get an order to go take the company's stuff, because the company is considered to be a different legal person than Bob. And you should understand that many of you probably have an LLC or a corporation that you operate your landlord business through with the idea that it protects you from liability and keeps things contained. It works that way with tenants too. A judgment, how long can it be enforced? How long is it good for? 8 years. Judgment is good for 8 years from the entry of that judgment. However, that doesn't mean you're out of luck when 7 years and 364 days come around. You can file a motion to renew a judgment, and almost always it will be granted if they haven't paid it. Once it's renewed, you've got another 8 years. You could do that indefinitely if you kept up on it. Most people don't remember the judgment a couple of years out. Sometimes the person you want to collect from doesn't have anything, and it's not worth pursuing. You might just give up on it. The other thing you might do is you might docket it out 4 years and have your reminder on your phone or something pop up and tell you and say, maybe I ought to go check and see if they're doing better now. Maybe they got a job, maybe they actually bought a house, maybe they have some assets. And you could also do a reminder that it's 7 years and 10 months, hey, I ought to do something to renew this to see if it's still worth doing. So those are some thoughts. You kind of have to be thinking out there and have a calendaring system that would remind you, but you absolutely can do that. All right, where? If your judgment is in one county, say you have a judgment against somebody in, oh yes, go ahead.
If you say you're out the 4 years like you say, can you get interest on top of that?
Absolutely. It's good if your lease has something about interest, because if it says 10, 12, 18% interest, something like that, then when your judgment is entered, you can have the judge enter that interest rate, the contractual interest rate that will go forward from that judgment. If you don't have that in there, there's a post-judgment rate that is set by statute that's quite low right now. It's about 2%, but it does accrue and it does build up on that judgment that you can collect. If you have a judgment in one county, oh yes, go ahead.
Why wouldn't he honor the interest rate from the time that they first accrued? Why would it have to wait till judgment?
They will, but that is included in the judgment.
Oh.
That's pre-judgment interest, and usually they calculate all that and say, well, here's the judgment, boom. And then they say, well, here's the interest rate going forward on the judgment as well. So you do get that, it's already added in. You have a judgment, let me finish this and then I'll get back to you in a second. In one county, and the person lives in another, you want some remedies to go seize their stuff, you want to get an order that's to the sheriff of that county, you can take that judgment, an abstract of it, record it in a different county, it becomes just as valid as if the case occurred there. So throughout the state, there's a way to collect anywhere you need to. If someone moves out of state, you can have it domesticated in that state. You'll need an attorney there to help you, and you can try to pursue it under that state's remedies. Sometimes the cost is prohibitive if you have a small amount, and so you may not end up doing that. Yes, what was your question?
If you do an eviction, do you have to take it a step further for a judgment, or does the judgment come with an eviction?
You do not. As Jeremy said, they're two separate things. Once they're out, the possession issue is resolved, so all that's left is the issue of how much is owed. You can choose whether you want to pursue that or not. And I have this discussion with my clients. Is it worth it? Do you think you'll ever get anything from them? Is it worth it for you to pay me the money it takes to go forward and get this to a judgment? You do not have to. You can let it sit there. After 6 months or a year, the judge will send out a notice saying, nobody's done anything in this case. I'm going to dismiss it if someone doesn't file something, and they'll dismiss it if it's not filed. That's dismissed without prejudice. You could still bring that up to usually 6 years after the breach by the tenant. You can refile another case if you wanted to. Yes.
How would the judge deal with attorney fees?
On your collection case,
Yeah.
if you have an attorney's fees provision in your contract, in Utah law, you cannot recover attorney's fees unless A, you have a contract that gives you attorney's fees if you prevail, or B, there's a statute out there that allows you to recover attorney's fees. A statute meaning a state law that's been entered on the books. Most of your leases, if you're using the UAA lease, you have attorney's fees provision in there. Most leases have that. That's important. If you end up evicting the person and then collecting, you can collect your attorney's fees on that, because the statute for eviction allows collection of attorney's fees even if you don't have a lease or even if the lease doesn't have an attorney's fees provision. Yes.
Why would you get a judgment rather than turn it over to a collections agency?
Generally, a collection agency will take it and they will harass the person and try to get paid. And that's about all the power they have, although they may have a connection.
Can't you just garnish their wages? It's not getting a judgment, you garnish their wages?
Once you have a judgment, you can, yes. To get a judgment to garnish their wages, you have to file the lawsuit and get the judgment and take the judgment to get the garnishment. You can't garnish until a judge has signed and said they owe you the money. Does that make sense? So, yes, and I'll talk about that in just a minute. Okay, collection methods. First, not only do you have the right to collect assets, you have the right to get information about the assets. I'm going to hold myself to this 20 minutes, so 9 more minutes, so hang with me. And I can talk with anybody after who has anything. You have the right to get an order to require the debtor, the tenant, to come into court and answer your questions about what their assets are. What do you own? Where do you bank? Tell me about your car. How much is it worth? Do you own any real property? They probably don't, or they wouldn't be rented. Where do you work? Anything about your assets, they are obligated to come in and answer the questions for you under oath. Sometimes they do, and sometimes they're honest. Sometimes they don't show up. If they don't show up, you can ask the court to issue a bench warrant for a couple $100, where a police officer will actually go out and say, I'm going to arrest you unless you give me $200 to pay this bail. The money goes into the court and eventually comes back to the landlord. And they can keep raising the amount until that person shows up and answers the questions. So that can happen. But to have that happen, you have to know where they are to serve them, too. Sometimes you can't even find them, so that can be a challenge. I just learned this recently. It's in this handout. I learned it from the state website, which I usually don't think of as cutting edge, but it told me something I didn't know. You can ask the court for an order requiring the Unemployment Insurance Division of Utah to disclose the name and address of the debtor's last employer. They would know if it's real, if someone's doing their payroll taxes, they will be receiving them. And you can file this motion with the court and say, court, please get an order telling the Unemployment Insurance Division to tell me what their last job was. They have an opportunity, both the tenant and the Unemployment Insurance Division, to object if they think there's some reason that shouldn't happen. But that is one thing you can do. If you just have no idea, but you think they're in the state and you think they're still working, you could try that and see what you find.
Is that in here?
Yes, it's actually under, on the page, these aren't numbered, I think it's the third page, debtor's last known employer. It talks about there right there. And this is all off the court's website, by the way. Very helpful. The last part is a little different, and I'll talk about that in just a moment. Okay, execution upon assets. This is where the rubber hits the road, okay? If you know of assets the debtor has, you can go to the court and get a writ or an order of execution, which means it's telling a sheriff, kind of like your eviction order tells a sheriff to go serve them and in 3 days kick them out if they don't get out. This says, sheriff, go take these assets, hold them, and set up a sale to sell them. And then when you sell them, give the proceeds to the creditor. So you can get an order doing that. It can be on personal or real property. Most tenants don't have a lot of real property, or they'd be living there. But they may have personal property. Maybe they have a nice stereo. Maybe they have computers. Maybe they have something valuable. There is an expense to have the sheriff or constable do this. So if all they have is kind of used, broken couches and stuff like that, usually not worth it. You can make their life miserable, but it doesn't benefit you a lot. And so I say don't even bother. If they have something that's quite valuable, if they have a vehicle with thousands of dollars of equity in it, and you look at the exemptions, I'll talk about it in a minute, it may be worth it. But most of the time, people that don't have a lot of nice stuff, you don't get a whole lot of that. Get a whole lot from that. Garnishment of funds. This is where you get some traction if somebody's still got a job. If you know where their job is, you can get rid of garnishment. Garnishment means instead of going after the stuff the debtor has in their possession, you go after somebody who owes the debtor money and you intercept it before it gets to the debtor. So you can go to their employer and you serve a writ of garnishment, a writ of continuing garnishment. It lasts for 120 days and the employer has to fill out a form. There's a certain subsistence level the state allows the person to keep. We don't take every penny, they'd starve. So I believe it's something like minimum wage times 40 hours a week or something like that. They can keep it, you can't garnish. Beyond that, you can garnish those funds. So if you get in there and you serve garnishment on the employer, they fill out the form. If there's money left over beyond that subsistence level, the employer holds that money. They send out a notice to the debtor and to the creditor saying, here's the money I've held, and some time passes. They have, I believe it's 10 days to file an objection. If no objection's filed, the employer sends the money on to the creditor. And that creditor applies it to the judgment, and then they wait for the next pay period, and the same thing happens again. Wonderful way to collect money if the person has a job, and you know where it is, and you can do that. Anybody, if anybody owns their own business in here, you might have gotten garnishment for your employees before. Anybody in the construction trades, Kennecott, a little bit more blue collar, tend to have a department that deals with garnishments because it kind of happens. Yeah.
What if the person being garnished or asked to be garnished, so there's garnishment going to the company, and the company says, well, yeah, they work here, but they're an independent contractor. Is there an exemption because they're an independent contractor?
You cannot garnish as if they're getting wages, but you can garnish the same way you would a bank. And that is, if they are going to owe them money as an independent contractor, then they don't have to fill out the form that talks about taxes and payroll and all that stuff. Instead, they just have to say, here's how much money I owe them. Or they have to say, they're coming up finishing a contract and I'll be paying them this day. And then they have to give you all of the money, I believe, because it's not employment, it's a contract. And
So-
they still have
So
to.
Jeremy received a judgment that was attached to, and then received a garnishment. A third party, I believe, received a garnishment. A client of mine was sharing this with me. The company in town says, well, we don't have to do this because she's an independent contractor.
That doesn't work unless they don't owe her anything. If they owe her anything, even if she's an independent contractor, then you can serve a different garnishment, which is the kind that goes to a bank, and they have the obligation to hold those funds and send out the notice just like a bank would. And so that's the other garnishment, is you garnish a bank account. The bank does the same thing, holds the funds, sends out notice to the debtor and the creditor, waits the time period to see if any objections filed. No objections filed, the bank sends the money along. If you were dealing with a garnishee, which is not the debtor, but the person that gets the garnishment, the employer or the bank, and they aren't doing it, you can, if they're not doing what they're supposed to do under the law, you can get a judgment against them to pay the money. So if anybody gets a garnishment for one of your employees, make sure you pay attention to it, because that may end up coming back on you if you don't follow the law the way you're supposed to.
Okay, so what you're just telling me is they are obligated for the amount of, if it's commission check, they are obligated to release that commission check to pay the garnishment.
Yes. I'm thinking through again whether they could go through the process of the subsistence level. I'd have to do some research on that, but for sure they'd have to pay you at least as much as they would if it was wages. I don't know if commissions fall in that category, they might. But they can't just say, oh, it's an independent contractor, I don't have to pay you. They have to send out responses to interrogatories. Interrogatories are questions to the employer or the bank that say,
Written?
how much do you owe them? Written. They have to send them back and say, we owe them so much money. If they owe zero, then they have no obligation other than to fill out the form. If they say, we owe them $200, they've got to hold that money. So Okay.
Let me ask you one other question. I received a judgment and garnishment and filed, they BK'd on me, but never, a BK was removed, released.
Undone, huh?
Undone. I don't know the term.
Dismissed, I think, probably.
Dismissed, yeah, that'd be good. So, 3 weeks later, I finally got about this, and I filed another garnishment. It sat on the company's desk, HR department's desk. I filed it on March 20th. Today, I have still not received a check. But I did get last week a notice sent to me saying that they were holding out X number of dollars. March 20th, mind you, sat on the people's desk. Do they have an obligation to go to the bankruptcy documentation to see whether it's been dismissed? Or is that my obligation to provide to them?
Most people get notice mailed out to them, but if you know bankruptcy's been dismissed and someone else is under the impression it hasn't been, I would go ahead and inform them.
Which I did.
When it comes to the garnishments, they need to act on them, and they need to act promptly. If it sits on their desk and there's not a bankruptcy situation and they don't do anything for a month, and in that month they paid out money to that guy that should have gone to you, they're going to be liable for that. They're going to be liable for that.
How do you hold them
liable for that.
accountable?
You actually file a motion with the court and serve it on them to have a judgment entered against them for
Well, you have
that
to
amount.
prove that you
That you
actually-
would have gotten some money. Yes.
Or that you actually informed them. Oh,
Yes,
right.
I mean, they have to get notice of what's
Yeah.
going on. But if a party served with a garnishment can potentially be obligated to pay what they would have paid had they done it right. So if they do it wrong, they may themselves be liable for what they should have paid. So I'm going to defer any other questions until the end. I'd be happy to talk to you about that at the end. Garnishments stack up sometimes. Any child support garnishment gets paid first above anybody else. After that, it's first come, first served. And they finish paying off the one before the next one comes into effect. So you may serve a garnishment, the employer may say, hey, I've got one ahead of you. So I'm paying that one, and as soon as that one's done, I'll start. That is legitimate for them to do. But they have to keep it, and they have to start their 120 days that it's valid once that other one finishes up. Garnishments can be very, very effective. Yes?
Some companies, if they come to garnish your wages, they just let you go.
They're not supposed to do that, but it may be something. It doesn't show that they're very good at managing with their money, that's for sure. Okay, attorney's fees, we talked a little bit about that. It's nice to get a judgment that allows you to collect attorney's fees after the judgment. The ones you try, that you have to pay for this garnishment, an attorney helps you. It's nice to be able to add that on to there. And if you get a judgment that says that and you have the attorney's fees in your lease, that'll usually happen. Very briefly about bankruptcy. If bankruptcy is filed, if someone tells you they filed a bankruptcy, try to verify that because there's an automatic stay, which means an automatic stop. Once someone files bankruptcy, everybody who is owed money by that person has to stop their collection procedures once they find out about the bankruptcy. If they don't, the bankruptcy court can come down really hard on them and sanction them and make them pay money and things like that. It's bad. So when someone files bankruptcy, now a lot of people say, oh, I filed bankruptcy. It's good to verify that. Say, well, give me a case number or give me your attorney's name. I just want to verify this so that I don't do anything that I should. If they can't come up with a case number and don't give you an attorney's name, then you kind of wonder. If they give you an attorney's name, call the attorney and say, what's the case number? And then the attorney might say, well, I've talked to him, but we really haven't filed yet. It's good to verify that. But be careful because you can get into trouble if you violate the bankruptcy stay when you know the bankruptcy has happened. If you don't know about it and you do things, it's forgiven because you didn't know. But once you know, you have to be careful. If you get a bankruptcy notice and it asks for a proof of claim, which is a statement that you're owed money, fill the thing out and file it. You may only get pennies on the dollar, but down the road you might get 20%, 10%, something, some money. It's worth having in there and doing that. Now, sometimes debtors get a discharge. That means through the bankruptcy, the court signs an order that says they don't have to pay you. Your right to go after them to get the money is gone. That doesn't mean that your other remedies are gone. If you have a guarantor or a co-signer, or if you held security, you may still have rights to pursue those. Bankruptcy of one person, if you have two people sign a lease, only one files bankruptcy, gets a discharge, you can go after that other one, as long as they haven't filed bankruptcy. So you can still pursue that.
I have another question.
Okay.
Someone files bankruptcy, but then it's dismissed.
Right.
We're notified that they filed bankruptcy. Are we entitled to know whether it's been dismissed?
Usually they will send out a notice, but
Who's
not
supposed
always.
to do that?
I don't know if the bankruptcy court does it to every creditor or not. If you filed something with the court, they will usually do that, but they're supposed to send that out.
Is a garnishment filed with the courts?
Different
Is
court,
it-
bankruptcy court as compared to state court. And so you better kind of check and make sure. You can always call the bankruptcy court to find out on that. Once the bankruptcy has been dismissed, not closed and discharged, but dismissed because the debtor didn't do what they were supposed to do, it is gone and it's like it didn't happen. That's different from when they get a discharge and then they close it. That means they're done and they got their relief. Dismissed means they didn't pay their fees, they didn't show up, something happened and they got rid of it, and so they have no more remedies under that anymore. So I'm going to wrap up right now, and then anybody who has further questions, Jeremy and I will stay here for a minute. Feel free to answer those, but I appreciate you taking a minute to listen to us.